As we're recording this, we have a slew of executive orders from day 3 of President Trump rooting out DEI, reversing all the stuff that Biden had done in terms of the political commissars everywhere, suspending anyone who's at any federal agency with a view of eventually letting them go, like a whole-scale assault on institutional DEI.
Somewhere I read of the freedom of speech.
You're listening to So to Speak, the free speech podcast, brought to you by FIRE, the Foundation for Individual Rights and Expression. Welcome back to So to Speak, the free speech podcast, where every other week we take an uncensored look at the world of free expression through personal stories and candid conversation. I am, as always, your host, Nico Perino. Today I'm here with Ilya Shapiro. Ilya is a senior fellow and the director of constitutional studies at the Manhattan Institute. He previously served as vice president at the Cato Institute and as the director of its Center for Constitutional Studies. He is the author of Supreme Disorder, Judicial Nominations and the Politics of America's Highest Court. And he has a new book that just came out titled Lawless, The Miseducation of America's Elites. This is the book we're going to be talking about today. At the end of the conversation, we might get into some current events. But Ilya, welcome to the show. It's been, 3 years since the incident at Georgetown?
3 years coming up on the infamous tweet. And I guess 4 years or so, 4.5 since we recorded something about my last book. So I appreciate this time being actually in person, in studio, not just Zooming everywhere. And I appreciate more generally, we can get into this, I certainly cover it in the book, FIRE's friendship and allyship, as they say, and for giving me kind of at least a master's, if not a doctorate, in crisis management during those 4 days of hell, as I describe the initial launch of what put me on this path to writing the book.
Yeah, so take us back to that time. You were gearing up for a big professional transition. You were going to start a new job at Georgetown. You're on a trip to visit some friends, about to put your head on your pillow. This is the time where there is going to be a change at the Supreme Court. You decide to tweet about it. What'd you say?
Yeah. So I had been at the Cato Institute for nearly 15 years, got an opportunity to take my career in a different direction to become the executive director of Georgetown Center for the Constitution under Randy Barnett. And that's an important center because, as we've learned, the rest of the law school is a center against the Constitution. A few days before I was due to start that job was when news of Justice Breyer's retirement broke. And, this is in my wheelhouse. My last book, Supreme Disorder, was about the politics of Supreme Court nominations and all that. So I was doing media all day while in Austin, Texas, with some business meetings, a friend's celebration of his job transition. And then, as you said, came back to my hotel room and was getting more and more upset that Joe Biden was hewing to his campaign promise to appoint a black woman to succeed Breyer. Not because a black woman couldn't be on the Supreme Court, of course, but because you shouldn't restrict your candidate pool, whether for janitor or Supreme Court justice, based on race and sex. And so not a best practice. I was doom scrolling Twitter, getting more and more upset, and fired off a hot take, as you said, before going to bed, saying that, if I was Biden, I would pick the chief judge of the D.C. Circuit, the second highest court in the land. Sri Srinivasan happens to be an Indian-American immigrant, very well-respected, progressive, all the things. But because of today's hierarchy of intersectionality, we would end up with a lesser black woman, by which I meant less qualified. The basic logic, if I have someone in mind as the best person, then everyone else in the universe is less qualified.
And this is the time before you could have a super long tweet. Elon Musk had not purchased Twitter yet. You couldn't have a book-length tweet anymore. You were still whatever the character restrictions
There were
were.
other grammatical errors and awkwardness in that tweet. Anyway, that's how it came out. So I fired that off and went to bed. And overnight, all hell broke loose. My ideological enemies went for my head, went for my job. Because, of course, if I had just been at Cato tweeting this, or now at the Manhattan Institute, I don't think anything would have really happened. But I was trying to go onto their turf, onto the left's turf at Georgetown Academia, and away we went. Protests on a mob protest, a letter writing campaign. I survived thanks to FIRE and many other friends, Camille Foster, Barry Weiss, National Review, Wall Street Journal, all these folks coming out publicly and privately behind the scenes to try to push at the dean, the lone decision maker. And so I wasn't fired the first 24, 48 hours. It was hellacious. It was my 4 days of hell. And ultimately, I was onboarded, but immediately suspended pending investigation on whether I violated the university's harassment and anti-discrimination policies.
What was the first thing you heard from the university?
Well, the next morning I woke up and I saw that this thing had taken off and not in a good way and was being willfully misinterpreted as saying I was racist and sexist and all these things. And I thought, oh no, this is not good. And so I took it down and I said,
do you regret doing that?
No. I have the question, should you have apologized, all that. I wrote that up for the City Journal, MI's.
I think we advised you not to apologize.
You did. You advised me not to do any of that. I came out with a very limited apology in the sense that, I wasn't going to say, sorry, I'm racist. I need to do the work and educate myself and all. No, none of that. I just said, look, this was a failure of communication, and it's become a distraction to my underlying point that you should have, merit-based, not race-based hiring and all that. So I took it down, and that was it. I very quickly had a phone call with Randy Barnett, who hired me. Who said, we need to get ahead of this, and eventually the dean, I think around lunchtime that day, issued a statement calling my words appalling and all of this, and he didn't know what to do. He neither, not exactly a profile and courage Bill trainer. He neither fired me right away or rescinded my contract, nor upheld my speech rights. He could have said, I don't agree with this. This is not good. Ilya needs to be a better communicator, but clearly protected by our speech and expression policy. He could have done that,
and it probably would have ended. Maybe not that day or the next day, but it would have ended.
Yep.
That's what we've seen in the past.
In the end, I ended up Zooming with him that Sunday night. And this is another surreal overlay to all of this was COVID mania was still in full effect at Georgetown. So I never met with either Dean Traynor, the DEI office, or Human Resources that were investigating me in person, because then we'd all have to be wearing masks. So it was kind of eye roll. But anyway, so when I Zoomed with the dean that Sunday night, he was like a deer in headlights. He kind of showed up, looked like clearly he hadn't been sleeping. This was like a big scandal in his world. And he, I said some opening lines, and I said, so where do we go from here? He's like, well, where should we go from here? I'm like, well, Dean, your policy is pretty clear. You should, I've said, again, not taking Fire's advice. I did say, sorry for the tweet. It was inartfully phrased. What I meant was clear. And 76% of Americans agreed that Biden should have considered all possible candidates, at least according to that rabid right-wing news source, ABC News. And I said, Dean, say what you want about not agreeing with me or whatever, but this seems pretty clear cut. But he didn't do that, and he punted. He punted to the DEI and HR offices, and away we went with this weird investigation, which very quickly became clear was not an investigation, but just kind of, an inquisition in some sorts. When I had the Zoom with the DEI office at Georgetown called the Office of Institutional Diversity, Equity, and Affirmative Action, IDEA. We had this Zoom, and they just kept asking me, what did you mean by the tweet? Do you understand why it's offensive? What was the context again? They kept asking me again, and it was so banal. And there weren't lawyers. It wasn't like I didn't feel like pressured or gotcha. And, after a while, soon after that, my lawyer was like, look, which Fire helped me out with, Jesse Benald, who set me up through Fire's network. He was like, look, do your job. Go back to commenting on the Supreme Court. Go back to tweeting, whatever. Don't, criticize Georgetown or comment on the investigation, but do your job, especially now, by that point, Justice Jackson was nominated or hearings were happening, all of this. He's like, do your job. Write about it, speak about it, do your job. And the longer it went, it became clear that this was not some meaningful there was nothing to investigate. They could have given it to a junior law professor there to look at the short facts, the tweet, the very short policies at issue, and apply a lot of facts, and that's that. But
instead, they brought in a high-powered white shoe law firm.
I imagine they spent like $1 million on this thing.
Really?
Wilmer Hale. I mean, they had several people there, the head of their, very high powered, at the end of which, 4 months later, once the students were off campus, surprise, surprise, to get it away from controversy, they had a junior associate look at a calendar and determine, Ilya wasn't employed by Georgetown when he tweeted, so none of these policies even apply. The good old jurisdictional nit. And so I was reinstated. I celebrated that technical victory, but then I got the fine print, this long report from the IDEA office, which I reprint for the first time ever in full in my book with some annotations and comments about it, which made clear that any time that I said or wrote something that would offend someone, that would create a hostile educational environment, and I'd be back in the Star Chamber. And so I realized over that weekend in June, so I was reinstated June 2nd. On June 6th, I resigned. And over that weekend, I put together probably my best ever legal work, my resignation letter, which is available on FIRE's website. Thanks for hosting that. I know a lot of reporters have gone there to look at it. A summary of that I published at the Wall Street Journal, as one does. And then the next day, I announced my move to the Manhattan Institute on Tucker Carlson's show on Fox, again, as one does. Yeah. And since then, I've been using that platform, which I was not seeking, but which I've been given to shine a light on the rot in higher education.
I should note why FIRE doesn't advocate for apologies. In some cases, you might feel like the apology is warranted, like you really, truly feel bad for what you said or what you did, but it doesn't, in the end, help with the disciplinary process or with the fight in the court of public opinion, because in many cases, these are witch hunts, and apologizing just self-identifies you as a witch to the mob and doesn't put them at bay. We've never seen a controversy end because someone apologizes. It just throws more gasoline on the fire.
Just to give a précis of why I did issue that limited apology, it was because I didn't care about the Twitter mob. They were not my audience. I didn't care about anybody who was criticizing me. I had an audience of one, Dean Traynor. Yeah. And I was strongly advised that it would help not get me fired in those first 24, 48 hours if I simply said, yeah, this is bad wording, I need to take it down. And that's how I felt. It was an error in hot take Twittery, Who among us hasn't done that? But anyway.
People wouldn't even blink at it today, I don't think.
I think that there's been a vibe shift, as we all say. But I wrote this up in detail in City Journal, I think in their spring issue last year. You set the goal, what is your goal? Is it to become a martyr and monetize? Is it to become some sort of free speech hero? Is it, to get in good graces with XYZ? My goal was to keep my job, period. This new job that I was transitioning to.
And I can say that was honestly your goal going through these four months. We were in constant communication, and you wanted your job.
That's
back.
right. I went to Georgetown for a reason. I could have stayed at Cato. I could have done any number of things. I eventually got a great offer from MI. But it seemed, for that matter, had I just wanted like a payout, I could have asked my lawyer, in month 2 of the purgatory, the so-called investigation, well, let's get a settlement, Here's the number I need to go away. And I'm sure there was a number like that for Georgetown as well. But we never started those kinds of discussions because, again, I was just, this needs to be vindicated. I need to see this through. So, anyway, in light of that goal, this was not trying to placate. I agree with what you said about the general thing about don't apologize. Or like right now, there's as we're recording this, an imbroglio about Elon Musk. Did he give a Nazi salute? And it's all bullshit. But and so he shouldn't be explaining himself or apologizing, because that's who would he be apologizing to? Yeah. There's no Dean Traynor that's the target. That's the decision maker or whatever. But in my case, I still feel what I did. I don't think in terms of process. I look back, I don't think there's anything that I could have done differently.
Yeah. Amidst all of this, you're going out, you're still speaking, you're still writing, and you have another experience at a different law school. And your book is about the unraveling of law schools, essentially. And you're at California Hastings College of Law, I believe on March 1st, to give a talk that you ultimately were not able to give. You stood there for what, an hour?
An hour.
As you were essentially just yelled at.
Yes.
right?
It was like an Occupy Wall Street rally. There was chanting and banging and all of these things. Like signs, I don't mind. You know, they were holding signs in the back, which is fine. The signs actually weren't blocking people's view. You know, there have been other disruptions where people hold up signs up front and between the speaker and the audience. That wasn't the case. It was the chanting, the banging. Sometimes the chanting started to die down, and I would try to, speak half a sentence and it would pick back up again. And the topic was the subject of my last book, Supreme Court politics. At this point, there was a nominee a month later after my tweet. And there was a professor there to comment. He eventually egged on the mob when I briefly stepped out to discuss with the Federalist Society officers who invited me what we should do. And I told them, look, you paid for me to be here for an hour. I'm going to be here for an hour. But this was the same month, by the way, that Yale had a speaker shut down. Ironically, with lawyers of the left and the right who agree on little other than the importance of free speech. Then it happened at the University of Michigan. This didn't get national media because for some reason nobody was live tweeting out that one. But so it was a real problem that spring of 2022. I'm actually coming back to what used to be called Hastings. It's since been renamed. It's now UC Law SF. I'll be back there next month in February. This is 3 years later, so completely different cohort of students. It's like, what is that? Dazed and confused. I get older, they stay the same age. So we'll see what happens.
What was the university's response or college's response in that situation? Was it a dean-trainer response?
So there were a couple of deans that showed up. First, there was the dean of students who was kind of a diminutive Asian American lady, and nobody listened to her. One of the small ironies.
She was trying to
get them to calm down and to tell them, like, our policy does not allow this kind of disruption. And they just spoke over her. They chanted. It had no effect whatsoever. Then a tall white man, basically the deputy dean, the head of academics, Morris Ratner, I believe is his name, came up and read them the riot act, and they quieted down for that at least. That is, they let him speak and to say what the university's policy was, what the law school's policy was. That is, you can't disrupt. You can have your signs. You can ask questions. You can't disrupt. Very standard stuff from FIRE's perspective. I just saw FIRE tweet out this morning about the Columbia disruption of the class yesterday. This is
the history of Israel. Yeah,
this is not exercising your First Amendment rights. You don't have a First Amendment right to disrupt student programs and classes. Very basic stuff. Anyway, he said he reiterated that policy. Then he went away. I came back up to the podium, and they continued chanting and banging. And then the next day, there was an email from the chancellor. I mean, this is a standalone law school, so the chancellor is effectively the head dean, reiterating what the policy was and that there'd be an investigation about things and these rules, both in favor of free speech and against disruption, would be enforced. But they weren't enforced.
Yeah.
And about a month later, there was like a further Deanly memo, 20 pages of basically nothing.
Yeah. Behavior that gets rewarded gets repeated. And when you have these disruptions and nobody gets punished, you're incentivizing it happening again. And unfortunately, that's what we see far too often in these shoutdowns. But we'll see if college administrators start to grow a spine as they seem to have political cover and they don't have the ex-mobs coming after them in the same way that they used to.
That publicity nobody enjoyed. I mean, these deans are generally not woke radicals or social justice warriors. They're careerist bureaucrats. And so they shy away from bad publicity or donors making noise or what have you. And so a few weeks later, I mentioned the University of Michigan, after there was a disruption of Jonathan Mitchell, who had been one of the authors of the Texas Heartbeat Bill. This is back before Dobbs. Now seems like years ago.
It does.
And again, that didn't make news because nobody was live tweeting or whatever. But the following week, I was due to speak at Michigan. And the deans apparently sat down the heads of all the student organizations and said, we are not going to be Yale and Hastings. Now, here are our rules. If you do something, there will be consequences. They read them the riot act, And the following week when I showed up and they changed my topic to discuss model civil disagreement with a professor they brought in from Northwestern. Their DEI dean even stood up and said, or not the DEI, I guess their dean of students stood up.
I hate when they do that, though. So, let's have this milquetoast conversation because we can't have a real substantive one.
Well, we weren't having a meta conversation about the importance of having conversations. We actually did discuss certain things. I mean, Andy Koppelman was the other professor, and he opened with, Ilya said much worse things than that tweet. I mean, come on. Did you see what he wrote about during the Obamacare litigation? He wants kids to work in mines and things like that, right? So it went off about this, and it became much more of a kind of a typical left-right thing rather than this postmodern thing about what speech is and what your privilege is and what happened to Judge Kyle Duncan a year later at Stanford with, is your juice worth the squeeze, and all of these harms and things like that. So anyway, this is fixable. It's not rocket science. We don't need to theorize whole new approaches to public policy to deal with these issues.
Yeah. During that shout down at Hastings, you decided to stand up there for an hour and essentially just take the hate. Why did you decide to do that? Most speakers are just going to leave the podium.
I was bemused. It might have been a bet. We were all wearing masks again. There was still that. So I was kind of like smiling or smirking behind a mask. And I never really felt physically threatened. I mean, at certain points, they did literally get right in my face without touching it and blocking access to the podium and things like that. But I never felt physically endangered. So I'm like, okay, if I'm not feeling physically endangered, if this doesn't seem like on the brink of a huge, melee or something, I'm just going to see what happens, whether I can speak. And literally, as I told the students who invited me, you're paying for me to be here for an hour. If they let me speak for 5 minutes, I'll speak for 5 minutes. If they don't let me speak at all, well, that's too bad. But I'm just gonna, you paid for my time. I'm gonna be here.
Before we look at the challenges of law schools today, let's zoom out and get your story. Why did you decide to go into law?
So I was born in the Soviet Union in Moscow, and my parents got me out just as soon as they could. I was 4 when we came to Canada, so I grew up in and around Toronto, and always was interested in legal political institutions, which is kind of a nerdy and precocious thing. But there it is. I was also into sports. I mean, it wasn't just a
Did it have anything to do with the family history?
Yes, absolutely. My parents taught me that communism was bad, and the family history with my dad's dad being arrested by Stalin's secret police, and then he and his mom were exiled to Siberia. All of these sorts of things that are not atypical of the Soviet period and especially of Soviet Jewry. So the way that we were able to get out was Brezhnev was letting Jews go to Israel in the late 70s, early 80s, and we got a visa that way. Didn't end up going to Israel. Ended up going to Canada, the first country that gave us a visa. And growing up, I would had this interest in why some countries are good, some are bad, governments, all these kind of, as my understanding grew. And also very early on, I began to prefer life, liberty, and pursuit of happiness to peace, order, and good government, which is the Canadian equivalent. So I also, one of the chips on my shoulder growing up for many years was that I wasn't American, and that we took a wrong turn at the St. Lawrence Seaway for all sorts of ideological reasons, as well as meteorological ones, I suppose, as well.
Did your parents feel the same way about America?
Eventually, yes, because they had some hardships growing their careers, and there definitely would have been more economic opportunity for them in the U.S. They were both material scientists, chemical engineers, working on piezoelectric ceramics and superconductors and things like that. They both got jobs at a defense contractor in Ontario. But they definitely would have had more opportunities in the U.S., I think. So I got to the U.S. as soon as I could. There's a separate discussion about the immigration system, but it was pretty much harder to get a green card than to come from the Soviet Union to Canada. I ended up getting the green card only in 2009, long after college and law school, which was in the U.S., and became a citizen 10 years ago now.
But why law?
Yeah. So I think by the time I got to college—
And where'd you go to college?
Princeton. And my parents said, fairly early on in high school, even though I was good at math and science, I told my parents, like, this isn't where my passion is. Like, I think I'm really more into like reading and writing, and the history is really exciting, and I don't know what that means. The lawyers seem to do interesting things. I liked LA law and its Canadian equivalent and that sort of thing. I recognize that's not reality, but anyway. And they were like, yeah, that's why we brought you to this country, so you could be whatever you want. I just realized we can't help you with your homework anymore. I was like, that's okay. I got it. So when I got to college, I pretty sure I was going to end up going to law school, and that's what I did at the University of Chicago with a year in between to get a master's at the LSE. I studied beer, theater, and rugby, and I think they gave me a degree in international relations for traveling around Europe while I was there. Good experience, and then came to the University of Chicago for law school, and it was an intellectual delight. Still didn't know what I wanted to do or what kind of lawyer I wanted to be. Had never heard of any big law firms. Didn't know there was such a thing as clerkships. I ended up clerking for a Fifth Circuit judge, which was amazing. And the way that I look at the law, the way that I organize my own team, very much like Judge Jolly in Jackson, Mississippi did. But it's all about, I wrote my undergraduate thesis comparing constitutional development in Russia and Argentina, because I spoke Russian and Spanish and got funding to visit places and talk to constitutional lawyers and stuff. But the way societies organize themselves, how to promote and preserve freedom, those were kind of core things with me from very early on.
It seems like you like your experience at University of Chicago.
It was great. I was actually just talking to their development office this morning. They reached out. I've been a donor for a while, and every 5 years I'm on my class reunion committee and things like that. As I detail in my book, the University of Chicago, certainly among the so-called elite schools, has been the exception in not bathing itself in mud over the last recent years. It's kind of a low bar, but they're doing something right.
So what do you see as the major problem with law schools today that have them bathing in mud?
So it's a microcosm of our broader crisis in higher education, which came to the national fore, I think, after October 7th, after Hamas's attack on Israel, and then the disastrous testimony of the university presidents, where it became clear that something is fundamentally wrong, and public confidence in higher education, and especially in the Ivies and the so-called elite places, really plummeted. Anti-Semitism, as Bill Ackman, the Harvard donor billionaire, would write the same day as it happens that Claudine Gay resigned the Harvard presidency. Anti-Semitism is the canary in the coal mine, that wherever it flares up historically is an indication of pathologies underneath. And here that's everything from academic corruption, moral relativism, a shift from education to activism, an abandonment of the core mission of any university to seek knowledge and provide a space for open inquiry and civil discourse, all of these sorts of things. Ironic that the heart of anti-Semitism in our country is in the most progressive, educated places, as it were. And in law schools, the reason why I focus on law schools in the book is because that's, of course, my professional background and my experience at Georgetown, what have you. But also, while it's sad when departments of English or sociology or what have you go off the rails, and unfortunate for the development of human knowledge, there are much more practical consequences with law schools, because after all, they churn out the next generation of our institutional leaders, the gatekeepers of our political and legal structures. Lawyers are disproportionately represented among elites of all kinds, and especially political governing elites, as well as C-suites in corporate America, as well as obviously prosecutors and so forth. So if they are being taught or acculturated in a way that there is no objective truth, legal institutions are illegitimate and need to be reworked, it's inappropriate to consider certain sides of particular issues. This goes against all professional norms and really threatens, I don't want to, with no exaggeration, threatens the pillars or the rules of the game on which our whole society is based.
So you think it's an ideological problem, largely?
No. And I want to be clear about this. There is a perversion of ideology. That is the critical theory coming back with a vengeance. When I was in law school in the early 2000s, critical legal studies, critical theory of various kinds, we thought that was some niche, weird philosophy that had, from the 80s and early 90s, that had been relegated to sociology departments. But then it came back about 10 to 15 years ago, with a vengeance. So that is a problem in terms of the teaching side and how not just the Constitution has problems with it, or civil rights laws enforce institutional racism or what have you, but securities law, water regulations, the entire legal edifice is problematic ideologically. Yes, that is a big problem.
Because I hear people say that it's a big problem about what they choose to teach and what they choose not to teach. For example, right now you have 5 justices on the Supreme Court who support originalism or a form of it, but you're not getting taught how to be an advocate in the originalist mold within law schools. And to me, that seems to be ideological, because why wouldn't you want your students to understand one of the main...
That's right. Yeah. They don't have to agree with it. It's not preaching originalism. It's being able to understand it so you can be a better advocate for your side. And you're right. They're failing that basic task of training lawyers. It's a professional school, after all. They're failing in that task.
So that seems ideological to me. And then it seems that the speech suppression that you experienced, whether it's at Hastings or at Georgetown, also seems motivated by ideology.
Those are symptoms. I want to make clear that, yes, there is that ideological failing, and that this radical illiberalism is something different than kind of traditional debates between originalism and living constitution, or different ways of looking at the law. This is not, Nico, the latest iteration of the decades-old conservative complaint about hippies taking over the faculty lounge. In fact, those hippies, the Berkeley free speech movement in the 60s, would now be, by these radicals, considered retrograde white supremacists, right? Because speech, well, that's your rights depend on where you are in the intersectional matrix or what have you. Anyway,
that's why people like Nadine Strawson came to your defense during the situation at Georgetown. You have these old school liberals who are almost aghast at some of the
what they're saying on campuses. A couple of years ago, there was some baby boomer history professor, I believe, who had a liberal by card carrying member of the ACLU and all of these sorts of things, wrote in the Wall Street Journal how he was afraid of his students. So ideology is definitely part of it, but that's only the basic thing. Everybody talks about that. That's a well-known story. The bureaucracy I cover a fair bit is astonishing. The idea, this started probably when you or I were in school, kind of the growth of non-teaching staff. And it started as kind of student support things, and Greg Lukianoff has written about safetyism and cognitive behavioral therapy kind of coming in through the dean of students' office and that sort of thing. It's a negative effect, to be sure. And then that exploded, especially in the last 10, 12 years, largely in the DEI space. And so you have these bureaucracies, these non-teaching staffs, who are even more to the left than the faculty, and not acculturated in norms of academic freedom or free inquiry. And they become the tail that wags the dog, with more non-teaching staff than faculty, whether you're talking about university.
And they all need something to do.
As Mansur Olson, the great political economist, talked about the growth of bureaucracies leading to the decline of nations. So just as in the public sector with bureaucracies there, I call this the educrats, the educational bureaucrats. Their incentive is to grow their authority and their budgets, to manufacture wrongs that they can then investigate, things like that. So that bureaucratic side is hugely important. And then the leadership bit. None of this would go forward if deans, provosts, presidents didn't allow it to happen. Because university officials, these leaders, are good at instilling whatever cultures they want: public service, entrepreneurship, social justice, whatever they want. And they could maintain a culture of free speech and open inquiry and whatever else. These basic classical liberal values of due process, equality under the law in the context of law schools. And that they don't. And that is another side of the institutional failure.
You talk about the shout down at Stanford in your book. This is Judge Duncan of the Fifth Circuit is set to give a talk at Stanford Law School, and is one of these bureaucrats, one of these DEI deans, who comes to try and quiet down the students, but in the process of doing so, throws gasoline on the fire, criticizes Judge Duncan, essentially asks him, "Why are you here?"
With prepared remarks.
With prepared remarks, yeah. So she was prepared to come here, and more or less take over his speech. I think her remarks were something like 8 minutes. It wasn't just coming and reading the riot act to the students. It was coming, editorializing, not just on what Judge Duncan had to say, but the mere invitation to him. The fact that students wanted to hear from him. He's a Fifth Circuit judge. He's a powerful guy.
And he was about to talk about how lower courts adjudicate cases in areas of uncertainty over COVID or what have you when the Supreme Court hasn't ruled. Something you would think people come to become students at Stanford Law to learn.
What did you make of the decision by some judges in the wake of that, and I think also the shout down at Yale, to decide, hey, there are just certain law schools we're not going to take clerks from?
Which was then expanded to Columbia after their failed response to the anti-Semitic encampments and disruptions and all that. Yeah, I support that. Jim Ho, the Fifth Circuit judge, is a friend of mine. He came to my defense as well at Georgetown, gave a talk, kind of dramatically ripped up his prepared remarks and defended me. I was on a plane when this was going on. I landed and had all these texts and emails from reporters asking for comment, and I just said, Jim Ho's a mensch. But look, and Lisa Branch from the 11th Circuit, I think they're the only ones who publicly put their name on the boycott, joined by a dozen district judges.
Is that still going on? Do you know?
As far as I know. I talked to Jim recently. He said that Yale alums have come up to him and said, keep it going. Just because Heather Gerken has hired Keith Whittington and then a junior professor, Garrett West, who had clerked for Alito and done certain other things, that's not enough. That means that she's paying attention, but we need to keep going. I support that because, first of all, it's prospective. That is, when he announced the boycott, the students that were already at Yale, they weren't affected by it. How else are you going to get their attention? It's kind of like during the Civil Rights era. If a dean announced policies that were still discriminatory against blacks. Could someone, would it have been improper for a judge to say, well, okay, I'm not going to hire from that school? Yeah, that would have harmed some kids who might disagree with the dean's policy. Well, then don't go to that school, and that's ultimately the impact I think that it's having.
Do you tell students to go to law school today if they ask you?
No, and not because my tune on that hasn't really changed with my so-called lived experience or this book or what have you. I think for too long, young people, very talented young people in this country, have gone to law school as a default. They don't know what they want to do with their lives. They've taken the LSAT just in case, just to see how they do, and they do well, and they're like, oh, well, maybe I should then be a lawyer.
Is that different than you? Your situation, you were interested in the world of ideas.
I knew I was interested in studying the law intellectually. I didn't know what I wanted to do with that. I still don't. I still joke that I don't know what I want to be when I grow up. I partly had issues of, my immigration status, so I couldn't have become a journalist because that's kind of more unstable. Couldn't have gotten a work visa or a NAFTA visa or things like that. So I had personal little things there with that. But I knew I wanted to study the law and have some sort of career that hopefully would encompass the academic, legal, political, and media worlds. I didn't realize that would be like at a job at think tanks where you kind of do all of those things at the same time. I thought it would mean, teaching a little bit, then going into the government, then going into whatever, going to being at a firm or whatever. But
when you're advising students about whether to go to law school,
it's just I liken it to converting to Judaism. So you come up and you ask the rabbi, and he says, no. And if you're persistent enough, well, maybe there is some reason there. Let's talk about this. Because, so many people, like I said, they just go there because, it's prestigious. Lawyers both make a lot of money, and it's kind of a good reputation, all this. Maybe this is what I should do. I don't know what I want. I don't want to be, I majored in history. I don't want to be a history professor. I don't know what else I would do, right? And I said, no, you have to have a good reason. Like, answer the question, what kind of lawyer do you want to be? What kind of law do you want to practice? Now, there are more opportunities these days than when I was coming out of law school 20 years ago to be a constitutional lawyer, to do public interest stuff, things like that. But still, it is not the right move for most people. Once we get past that stage about, should you go to law school, then we can talk about, which law schools, how do you approach it, how do you prepare, all of that certain thing. But, I've had the opportunity, the privilege, the pleasure to interact with a lot of bright young people. Gosh, young people. I think I still think of myself as young, so I don't know how, I go to college campus, like, why are these middle schoolers in college all the time? Yeah, it's not the right answer for most people, but if you're focused and you have a good head on your shoulders and you have again, goal setting, so important. Don't know how you're going to get there, but set the right goal and it might work out.
You write in your book that some of the challenges that are seen in law schools have graduated, so to speak, into the real world. You write, the Overton window shift we've seen in law schools has graduated into the real world. You write that law firm partners cower in fear of their associates who question their firm's representation of certain types of clients and demand that statements be made. You suggest or state outright that the American Bar Association has become captured ideological, is trying to shape the way that law schools teach.
It ratified Biden's deeming the Equal Rights Amendment to be part of the Constitution. I mean, come on. As did Georgetown, by the way. Those are the two major institutions I saw on Twitter, at least, that said good things about this, just willing a constitutional amendment into effect.
Have you heard from people, or do you hear often from people outside of legal academia about the challenges that they've seen at the law firms that they practice at?
Yes.
Whether in their professional institutions? What are they saying?
That they have to bite their tongue, that they're not allowed to take on certain clients, whether pro bono or even paying sometimes, oil companies, for example, politically incorrect. Even as their counterparts on the left can take lots of kind of controversial positions, they're not allowed to in various ways. I mentioned the story of a friend in my book who was at a big firm, and after Dobbs, the overturning of Roe v. Wade, she declined to take on abortion rights litigation. And, citing I'm too busy, what have you, not making a political stink over it. And finally, the managing partner called her in and said, "Oh, I bet you're pro-life. What a waste of a female equity partner."
Wow. So
she got a nice settlement out of that and started her own firm. But that is not atypical. And, it's not just, the stories that make national news are evocative of a much bigger problem. So Paul Clement, possibly the best lawyer in the country, best Supreme Court advocate, had to leave his firm because they wanted him to fire his client because he'd won a Second Amendment case at the Supreme Court. Even though when he went to Kirkland, he and his colleague Aaron Murphy negotiated that they could keep their clients in this precise scenario. Would not happen because it had already happened to them at their previous big law firm. So
is this still going on amidst the vibe shift?
Again, where we have a vibe shift, we're in the eye of the storm. In corporate America, apparently there are some changes, and we saw some developments where like Netflix was not going to be bullied into taking down Dave Chappelle.
Yeah.
Yes, things like that. State Farm. In corporate America, there have been examples of the pendulum swinging back. At law firms, I think it's going to take longer because they're more left wing on average than your average corporate CEO, who is kind of doing things based on what they think their financial advantage is at any given time.
Well, let's steelman it a little bit. What's the problem with law firms doing this? What's the problem for the legal profession with law firms that are particularly ideological in this way?
It's the same as law firms in the 50s and 60s who said, we'd love to hire more black lawyers, but our clients won't stand for it. I mean, it's just morally wrong. And it does a detriment to our society that, politically incorrect clients can't get representation, whether you're talking about some individual who's been improperly railroaded by a politicized prosecution, or oil companies or gun manufacturers. I mean, this undermines the basic corporate governance of our capitalist economy.
Yeah. There also seems to be a lack of understanding, or at least appreciation, for what has historically been seen as lawyers' roles. You talk about it in the criminal defense case. You had Ronald Sullivan, who was a dean at Harvard, who was driven out of one of the houses that he was overseeing because he represented Harvey Weinstein. The association of the client with the advocate is tighter now than it seems to have been historically, where it was understood that even if a client is abhorrent, or you find them offensive, or you find what they're alleged to have done detrimental to society, you still, particularly in the criminal defense space, want the government to prove its case. You don't want someone to be able to just get railroaded, or even in the civil space. To the extent people have a viable claim, they should be able to utilize the legal system to pursue it.
And recall 20 years earlier when Big Law was jumping over itself to defend Guantanamo prisoners, not because they agreed with them or necessarily thought they were innocent, but because they thought that that's what our legal system demands.
Well, what is the problem right now with the American Bar Association? I don't know that folks have a full appreciation of what the association does as it pertains to the legal educational environment, but also just the legal profession in general.
So the most important thing to know about the ABA for purposes of this dynamic we've been discussing that I wrote the book about is that they are the sole accreditor of law schools. They have a Department of Education granted monopoly over the accreditation of law schools, which is not the case in undergraduate institutions. Which means you can't have a University of Austin law school rise up because they would not get ABA accreditation, presumably because of DEI standards and other things that the ABA puts into effect. At this point, the ABA is just another left-wing interest group. It is not even father's, not your grandfather's ABA, where Lewis Powell parlayed his presidency of the organization into a Supreme Court justiceship. I mean, something like that wouldn't happen now. The president of the ABA, nobody knows who that is. Leaders of the legal profession don't know who that is. It's not an important person. It's arguably less important than the leader of, the NAACP or Planned Parenthood or one of these other kind of name brand activist organizations. And nevertheless, it purports to speak for the legal profession. And it would be one thing if it spoke for it in the context of lawyer regulation. Should state bars be so powerful, or what kind of ethics guidelines need to be updated for the AI space or something like that?
So they don't have a formal relationship with the state bars that license attorneys?
Sometimes they do. It depends on the state.
Okay.
And most states require you to graduate from an ABA-accredited law school to get a law license. There are some exceptions to that. California notably has non-ABA accredited law schools, so you can practice within California, but they are a gatekeeper to the state bar in that effect, even if they're not directly empowered. Although in many places, the state bar regulatory authorities just kind of adopt the ABA model rules for whatever it is. But anyway, as I was saying, they don't just take positions on legal ethics or what have you, but on the controversies of the day, whether it be abortion or the Second Amendment or affirmative action or anything else, filing briefs, taking institutional positions. And that and all these other developments is why it's declined in its importance.
So you see that as a departure from their core mission. We often talk about colleges and universities taking positions on the issues of the day, and they're increasingly not doing so, adopting postures of institutional neutrality. Is that not something
the Calvin report from Chicago, right, which is, I think, a good practice that they're relearning so that they're not forced to take positions and argue over that. They can just say, individual faculty or students can say whatever they want, but as an institution, that's not our role, except when it affects the university directly. And so similarly here, the ABA is supposed to be the lawyers' industry group. So if there's something coming down the pike, whether in a state or from Congress that affects the legal profession, they should be able to opine about that. But general run-of-the-mill political controversies where their membership is understandably split, even if not 50-50, that's not their role. And so now, I don't know what the latest stats are, but it's something like 10 to 15% of lawyers are members of the ABA. And it used to be, much more than half. It used to be a comfortable majority.
Do you think we've reached peak cancel culture?
I thought you were going to say peak woke, because I think that the answer is actually different, and they're two different questions.
Well, answer them both, because I'm interested in the other one as well.
So I do think, somebody asked me this recently, was my experience with Georgetown and or Hastings the peak of wokeness? And the answer to that is no. But I think it may have been.
That had to have been the summer of 2020, I think.
It was
peak wokeness?
Well, that was when it flared up. I think it continued growing after that with companies, institutions' reactions and instituting DEI policies and things like that.
The next year or so.
But cancel culture, I think, has gone down, and it could be that my period of early 2022 was indeed peak cancel culture, because we've definitely seen a vibe shift there. We're no longer seeing executives being fired for this and that.
I think it's underappreciated how much Elon Musk's purchase of X contributes to that. Whatever you think of Elon Musk and the politics, Twitter, now X, was the driving force behind many of these cancel campaigns, including yours.
Including the very first notable one, the woman who got
Justine Sacco,
who went on the plane to South Africa. And
when you said that you tweeted and then fell asleep, the first thing that came to my mind was Justine Sacco tweeting and then getting on an airplane without Wi-Fi for however many hours.
Right, and was fired by the time she landed. Yeah.
Yeah.
So X, Twitter plays a big role in that. So I think Elon Musk's purchase can't be overstated in importance. In terms of peak woke, the jury is still out. I think in society writ large, certainly the pendulum has been pushing back. And as we're recording this, we have a slew of executive orders from day 3 of President Trump rooting out DEI, reversing all the stuff that Biden had done in terms of the political commissars everywhere, suspending anyone who's at any federal agency with a view of eventually letting them go, like a whole-scale assault on institutional DEI, which is part, maybe even most of the story of woke, but it's not everything. And that's just the federal government. In our culture writ large, I think there's continuing work that needs to be done, continuing pressures kept. And in academia, I don't know. Society writ large, I'm with Brett Kavanaugh. I live on the sunrise side of the mountain. In academia, maybe we're past the point of no return. I don't know. We're in the eye of the storm. There's a battle. The battle has been joined, but there's massive resistance, and I choose that term advisedly. Both to the Supreme Court's decision ending racial preferences, SFFA versus Harvard, about which there was a separate executive order just this morning, reversing not just President Biden or Obama's executive orders, but Lyndon Johnson's that instituted affirmative action in the first place. Obviously going to be a lot of lawsuits. At the end of the day—
Do you think there's going to be a lawsuit back up at the Supreme Court and dealing with corporate America at some point?
We will see. Well, SFFA hasn't been legally mandated to be extended to corporate America. The interpretation of—
Well, that's why I'm asking.
Yes.
You think they'll take the principle applied there and extend it to corporate America, where you have racial preferences?
Assuming there's a circuit split. There might not end up being a circuit split. It could be that if these things are litigated and all the lower courts, even the First Circuit based in Boston that has no Republican-appointed judges, even if they agree that, yes, SFFA doesn't directly apply, but the logic is inexorable that you can't treat people differently based on race.
You'd also have to have a corporation that's willing to take it all the way up to the Supreme Court, which I'm kind of doubtful of, at least in the short term.
Right.
So
there are interest groups, as I detail. There's even the Association of Higher Education Diversity Officers, which has thousands of members. This is a huge industry.
I debated DEI at one of their events.
I mean, they are not going to go gentle in the good night, as their entire industry is completely threatened by this. So there'll be lawsuits, there'll be arguments, and the media is not going to be just lying down for this. So we are in. This time around, the Trump administration is lawyered up a lot better, both in terms of how these executive orders are structured and who's in place at the Justice Department to defend them. And general counsels in corporate America, I think this morning, are all huddling up about what
I saw that on the front page of the Wall Street Journal. Yeah, or at least the front web page of the Wall Street Journal, that they're huddling up. I will say, at least on the academia side, over the past 2 years or so, FIRE has received more requests, often private requests, and they ask that these requests remain private, to come into colleges and universities and advise them on how they can navigate this current moment and bolster their speech protections. Because I do think there is a recognition, based on some of the conversations I've been in, that the pendulum swung too far, that they were admitting the wrong sort of students into the college who didn't quite understand what the mission and purpose of the college was, as well as the recognition that they're not teaching these students.
That's another point. We've been talking about different kinds of deans. Deans of admissions are also a problem in terms of putting the thumb on the scales for activists rather than scholars. For law schools, if you write in your personal statement that you want to change the world, that's going to go out a lot better at a place like Yale or Stanford than saying that you want to prosecute child molesters or you want to make our markets more efficient for the American consumer.
Yeah. So
That's good that FIRE is being queried as a consultant for these sorts of things. But, there are an awful lot of colleges and universities in this country, and a lot of their leadership thinks that they can just fly under the radar. We're not Yale, we're not Stanford, we're not going to make national news when something happens. Ohio Northern University is still locked in litigation with Scott Gerber, for example, a law professor there. The Ohio Northern is the law school. It's not the smallest law school in the country, I don't think, but it's the law school in the smallest town, located in the smallest town, Ada, Ohio. And they frog marched him out of his class they wouldn't tell him for a while, for like a year, what the charges even were. It was this Kafkaesque nightmare. I put him in touch with the Wall Street Journal so at least he could get his story out and he can get representation from, I think, America First Legal is representing him. But they won't settle. They've offered him like nothing. They've mediated in bad faith. This thing goes to trial in April. Just ridiculous. If you read the docket, this is an Ohio State court, Gerber versus Ohio Northern, just, again, smaller schools that are not the Ivies, that are not going to get attention, think that they can let this controversy blow over. And it's going to take a full, nationwide, campus by campus approach.
I don't want to pass up the opportunity to have a prominent Supreme Court watcher on the show and ask about the First Amendment Supreme Court arguments from this past month, starting with TikTok. What are you making of that whole mess right now?
I am disconcerted that I find myself on the other side from FIRE on both of these cases that we're going to be talking about, the TikTok case and Free Speech Coalition versus Paxton. But I figured out a way to square the circle. It's because these cases are not actually about the First Amendment and speech. Here's why. Harder case to make for Free Speech Coalition, but that's a separate sort of thing. For TikTok, and the court unanimously agreed with me, which doesn't necessarily mean that it's right, but it gives me some comfort that Thomas, Roberts, and Jackson all were singing from the same hymnal, that this is about ownership. And if you look at the legislation about TikTok, it didn't say TikTok has to change its algorithm because it's rotting teenagers' brains or is harmful to American political discourse. That's a separate kind of argument that some states have tried to make, what have you. This is simply about ownership. And we've had a tradition, whether through the FCC and communications networks or through CFIUS and the ownership of ports and other sensitive infrastructure, that foreign control of these things has been regulated as a national security concern. Now, we can argue about whether that balance has been written into the law improperly, or in this case, whether there really wasn't a national security concern, that Congress was acting out of a sham interest or what have you. But bipartisan legislation passed in April of last year said that TikTok has to ByteDance, the Chinese-controlled parent company, has to divest itself, sell TikTok, or not be able to operate in the U.S. So it's not a TikTok ban because TikTok is bad. It's a divest or stop operating because of the concern of data mining by the Chinese communists and algorithmic control. And so I agree with that. I'm actually doing a debate tomorrow at Cleveland State, or a panel about this TikTok issue. And I fully agree with my friend Mike Gallagher, the now former congressman who designed the legislation. Again, drew broad support. I just don't think it's a free speech case.
The court says it was an as-applied challenge. But if you look at just the law itself, do you not see any content-based regulation in it?
I mean, there's a definition of what a social media platform is. I suppose there's some context there.
But particularly the applications that are exempted, whose primary purpose is to allow users to post product reviews, business reviews, and travel information and reviews. Those are exempted. To be able to determine what's covered, you need to look at the content, right?
I mean, I've heard this argument made a different way, that there are other platforms that similarly allow hostile powers, Chinese or otherwise, to get at our information. So, the TikTok is being singled out or something. I mean, at a broad enough level, at a high enough level of generality, I suppose you could make a content argument, but I don't think it's really valid in the sense that, we've identified this particular platform as transferring data to a hostile power. Period. We're not going to allow that. The solution isn't
even if people do it voluntarily. the disclosure requirements doesn't do it for you.
Right. We have national security regulations of various kinds. And again, we can debate whether those are proper or not, but this was, I think, inappropriate, akin to blocking the Soviet Politburo from buying one of the three networks at the height of the Cold War.
Sure. I think where FIRE has disagreements with a lot of other First Amendment advocates, stalwart First Amendment advocates, is probably around what level of scrutiny needs to be applied to it. So, for example—
But you know that those scrutiny levels are artificial anyway. They're judge-made.
I know. We'll get into that as well during the Free Speech Coalition v. Paxton one. But if I'm looking at it from a broad level, I want to know what the implication of this decision is, as the court in its per curiam decision points out, for mixed justifications, for laws that are passed that have a content-based motivation and a content-neutral motivation. Here, the content-neutral motivation is data privacy. The content-based one is what platforms are covered, what ones aren't. It necessarily requires looking there. And I can just see a lot of mischief coming from that, because when we do litigation on campus and off campus, you often see mixed motives in some of the cases that we're looking at. And if courts and judges, and I know they say in this decision that their opinion is narrow, but we know how courts actually will apply things and how advocates will try and expand the otherwise narrow opinion to mean much more. I can see a lot of mischief being played when free speech issues get litigated surrounding this mixed justification motive.
That'll have to be taken up as applied in the next case. And I think Gorsuch's concurrence is obviously only speaks for him, but he comes at things a little more, and he's probably the most speech protective justice.
I think we would have been a lot more happy with. I'm not saying we would have been totally happy, but if his opinion were the per curiam opinion, or his occurrence was the per curiam opinion, we would have been a lot happier. But I do wonder how this just plays out, right? Because TikTok theoretically is available on the free and open internet outside of the United States. So people, I guess, can use VPNs to still access it. It's just the ISPs and the app stores.
Let's say there was an app that's freely identifies as "We are America's enemy. We want all of America's data. Please sign up," and people do. I think the United States could block that out of national security concerns. I think that's what this is.
When you look at the Lamont case from 1965, that involved a Chinese publication. I believe it was the Peking Review. And the court held that users have the right to access this information. That was a case that involved people having to tell the post office proactively that they wanted to receive it. So there was an added burden placed on the speech. Is the difference here that the data that's transferred, you're not just sending the Chinese Communist Party, which owns the Peking Review, your address and name, and that you're interested in these ideas. It's the algorithmic-based data mining that's
I think that matters. It also matters that all the justices also agreed that ByteDance doesn't have any First Amendment rights. Foreigners don't. Mm-hmm. So then you're talking about the individual users.
Which really wasn't grappled with much in this case, I think, because of who the petitioners are. They were content creators, and then they were TikTok itself. But I think a user case would have been interesting. Someone say, I have a freedom to access this information, which is an underdeveloped area of law in the First Amendment space.
And the answer to that would have been, well, okay, but we're just blocking them from getting your information.
Free speech.
Yeah.
What was the last thought?
No. Let's move to Free Speech Coalition. I'm actually debating former FIRE staffer Darpan Asheth next week on this case at Penn Law. We'll see if anything happens at Penn Law. It's another place that has had some issues the last few years.
Yeah, Amy Wax, for example. So Free Speech Coalition v. Paxton, this is a case coming out of Texas. They're requiring age verification on websites that have, I think, something like 30% or more adult content. It's not just age verification. They also are requiring a health warning label on this content as well. And the question that's up to the Supreme Court is what standard of review should be applied to this law. The Fifth Circuit applied a rational basis standard. Usually when you're talking about context-based regulation, you're not talking about rational basis standards. So I think that's why the Supreme Court really wanted to look at it. So it could be the Supreme Court will say, you need to apply strict scrutiny. Fifth Circuit redo it. Fifth Circuit redoes it and comes up with the same exact
result. So I'm less interested in the standard question. Not going to fight the hypothetical. I just don't care that much because these standards, the scrutiny land, as Randy Barnett called his famous article from almost 20 years ago at this point, is all artifice.
That's kind of what Gorsuch says in the TikTok concurrence.
Yes. The point is, does the government have a good enough reason for infringing on a right? And everybody agrees that the government can restrict minors' access to pornography without getting into a definitional debate over obscenity or adults' rights, but minors' access to porn. Again, that was reiterated during the argument.
That was the Ginsburg case.
Yes. The lawyer for the porn sites agreed with that proposition. So the only question then, it seems to me, is does this technology for age verification burden adult rights? Has the technology advanced far enough that you're executing what the state can do, block minors, without burdening adults? And it seems like, at least that's what my brief for the Manhattan Institute and a bunch of scholars, interdisciplinary scholars, is that, again, I'm just a simple constitutional lawyer, but the materials I was given and what I ended up writing and submitting was that the technology now, unlike in TikTok, you're not hoovering up everything from your biomedical data to your financial stuff to your retinal scan and whatever. All it's doing is verifying your age, and it's less burdensome even than inputting a credit card that's then stored, and if there's a leak, then someone can see that your credit card was used to access a porn site. That was technology from 10 or 15 years ago. Now it's less burdensome, and to me, it checks out. To me, it is not. It's doing what government can do without imposing a burden on adults.
Yeah, I've always had the question about how you would actually enforce the law and ensure compliance, right? Is it just that they have this technology in place? Let's say they allow a minor to access the material. Are they not going to be held liable for that so long as they go through this process? And how would you even determine if it was a minor versus someone else accessing the material if you can't keep a log of who is logging in, right? Like there has to be some sort of log to determine whether compliance is happening. But maybe
ultimately that's up to the Texas Attorney General, I guess, how they want to enforce it. The court is evaluating the law as written and how it can be applied. And if to me, it's a question of technology. If the technology is there such that really adult rights aren't burdened, you're just very quickly no 24-hour waiting period, or where you're just very quickly verifying your age, and then that information isn't stored or connected to your identity or whatever else would be a burden, then it should be able to go.
What do you think about the question before the court, though, whether rational basis or some higher level of scrutiny should apply? Because if rational basis can apply, and we know what rational basis means in practice.
It means the government wins.
It means the government wins, or they could theoretically just ban pornography, because that would be a rational way to prevent minors from accessing porn, right?
Which the court is never going to say that. And they're not going to want to go back into the obscenity wars of, I know it when I see it. And,
yeah.
Probably strict scrutiny is right, or heightened scrutiny of some sort.
So you think they would overturn the Fifth Circuit and say you have to apply a higher level of scrutiny?
They could reverse and render. They could. No, I guess they wouldn't, because they would. They wouldn't answer the question in the first part. Or unlikely to. Yeah, I think probably the most likely thing is, as I said, there'd be a lot of language about how the rule that the standard is strict scrutiny, but a lot of language about how this probably survives.
Yeah, I could see how this could survive under strict scrutiny. But I don't see how the labeling requirement can survive under strict scrutiny, which is another part of this law. Particularly
compelled speech, yeah.
Yeah, particularly because the warnings say that there are psychological damages and danger that come from viewing porn, and the Texas Health and Human Services Commission hasn't actually announced findings that would give credibility to what they're compelling these sites to say. So that, to the extent when you're applying.
So it's not as justified as labels on cigarettes or something like that.
I don't know. It might not be. You'd have to kind of look at the record in that case. And I think it does matter what the health establishment finds when determining whether.
That could be, but it's a completely different question because the labels presumably are targeting adults at that point.
Yeah. It has kind of brought up anonymous speech, which you recently wrote anonymous speech insofar as people want to be able to access this content anonymously. You recently wrote about masking as well, and this was for the free press. And we know that in the wake of COVID, everyone started wearing masks. COVID has waned. People are still wearing masks, and they're doing so in the commission of crimes to clearly kind of cover up their misdeeds. You write in your piece that prosecutors and law enforcement in the city of Philadelphia, for example, are having a hard time prosecuting thieves or arresting thieves. What do you make of the whole you tip your hat to the free speech concerns. I know the jurisprudence on it isn't, from my perspective, all that great. It has a legacy that relates to the Ku Klux Klans and the mask that they wore. But I have a hard time saying, okay, people can't be anonymous in public at protests, and then transposing that principle to the internet, for example, where I think you need to have a right.
I don't know if it's the same concern, because I'm not making an argument about using pseudonyms when you write or something like that. This is purely in public, masking to conceal your identity so you can't be identified and prosecuted, whether for shoplifting or whether for intimidating and harassing or being engaged in a protest that blocks a street or any of these sorts of things that are illegal.
But you can wear a mask in public because you don't want to be associated with a disfavored cause or to commit a crime. In the same way you can online. Like, you can use Signal just because you don't want to be associated with a disfavored group that you're talking with, or to engage in speech integral to criminal conduct. And we had this debate in the 90s a little bit over encryption as well. And Bitcoin comes into the play as well. You have all this anonymous stuff happening on the internet, some of which is benign and protected, others of which is not. And so I don't see how you clearly delineate that either in the real world or not. I could see making the case for wearing a mask being an aggravating factor, for example. But that also presumes that you can catch the criminal in the first place.
Right.
So
someone who's a bank robber, I think, is going to be less concerned about a sentencing enhancement for wearing a mask while you're robbing that bank. So I don't think that quite does the trick. Mm-hmm. And New York had the longest, had the oldest anti-masking law in the country until it repealed it during COVID, and has never put it back. And that's created a huge problem for identifying the people who took over Hamilton Hall at Columbia, for example. That Alvin Bragg, I'm sure, partly let them go for political sympathies, but also because it was very hard to establish people's identities and who did what.
The protesters at Columbia who disrupted that class that you had referenced earlier were also wearing masks.
Yeah.
Too. No, I get the problem, for sure. I get the problem. I just want to be able to address the problem in a way that doesn't create bigger problems for free expression. And in your piece, you talk about that as well.
Someone who wears a mask is generally up to no good. I mean, you might have a legitimate reason because it's what feels like 1 degree
unless
outside
they're celebrating
now.
Halloween.
Well, Louisiana's anti-masking law makes an exception for Mardi Gras. So I don't know if there's a spike of shoplifting during Mardi Gras because of that, but
yeah. Well, I guess while we're here too, and we're talking about all the ways in which you disagree with FIRE in certain respects, and I should note that there are many, many places we do agree, and your book makes clear.
FIRE is my favorite organization, and I told you and Greg and the others that were just truly helpful. You're in my acknowledgments, as I'm sure you realize, not just the index for the Washington Read, but in the acknowledgments, I hope to be one of your big fundraisers, and I've never said no to any request that y'all have made of me. But
you spoke at our gala.
That was a great experience.
Right after Killer Mike or before Killer Mike?
Introduced by Nadine Strawson as the opener for Killer Mike. I mean, which other organization but FIRE would that happen with?
But the one other place where we disagree is also the IHRA definition, International Holocaust Remembrance Alliance, I believe is the full acronym.
Which Harvard just agreed to as part of their settlement of the various lawsuits against it.
Yes, and they also expanded it because they included anti-Zionism as a form of anti-Semitism.
I think it clearly is. Which I go into that a little bit in the book. Let's not go down that.
No, we don't need to go down the IHRA definition, but I do worry that every other group is going to ask for their examples of anti-racism, anti-sexism to be included and to have a formalized definition. I know you have broader concerns about courts trying to define what is or isn't anti-Semitism or racism, but I definitely have a concern by the CRT people embedding in some sort of definition that gets adopted by a college or the federal government that enshrines systemic racism principles surrounding anti-Black racism, for example, which is a protected category.
So I agree with Fire that the Davis holding should be the gold standard in terms of what is harassment, what public institutions can regulate, how private institutions' policies should operate. That harassing someone based on various protected categories and things like that. And I've had this disagreement with Fire in the context of the Anti-Semitism Awareness Act, which I imagine is going to be reintroduced in this new Congress. It might have already been passed one of the houses, I'm not sure, but which adds some flesh onto what anti-Semitism is, because it's never been defined. And I also agree with Fire that some of the examples in the IHRA thing can be problematic in a vacuum, but the Anti-Semitism Awareness Act, as I wrote in a letter to the editor at the Free Press, responding to my colleague Chris Rufo, with him I fully agree about DEI and CRT and all those, and Janine Eunice at the National Civil Liberties Alliance, who I've also supported with briefs in other kinds of cases. The act itself says that it does not infringe on the First Amendment at all, does not change the scope of Title VI or anti-discrimination law. It simply is a definitional thing.
But we know how those savings clauses work in practice, right? I mean, there's whenever you change a law, I suppose it's room for litigation.
Lawyers always win, but I think it's a necessary component of these groups that say, oh, well, we're not really going after you because of your background or religion. We're going after you because we don't like your ideas or we don't like Israel. Query: why are you protesting a Jewish student organization if you don't like what Benjamin Netanyahu is doing? But I think it's necessary, and I've been satisfied of First Amendment concerns.
The problem with Harvard is they adopt it. But
I'm sure there are many problems with Harvard. They don't have the Davis
standard for their
I am not opining on the Harvard settlement. In fact, Shabbos Kestelbaum, who's the kind of the figurehead of the, made a big splash in a former Democrat who was all in with Trump because of this issue and the Harris campaign not listening to students being affected by the encampments and all of these sorts of things. He did not go along with the settlement, so he has gotten separate attorneys to continue his case against Harvard. So I haven't read the settlement. I'm not going to opine about whether it's good or what it's. I'm sure there are problems, and I'm sure Harvard is going to try to weasel out in all sorts of ways.
Yeah. Well, one of the problems is that they don't have the Davis standard for non-discrimination and bullying. They use the or instead of the and formulation of severe, pervasive, and objectively offensive. So, we'll see how it all plays out. I'm sure, as you note, the Anti-Semitism Awareness Act will get reintroduced, and we'll see what it goes. But Ilya, this has been fun. Congratulations on the book. I know these are labors of love. Although, would you describe this one as a labor of love? It seemed like it was almost kind of painful to write and revisit.
More like a forced march, yeah. I mean, the part about myself was just cathartic, and I had to get that off my chest.
You found out you were having twins when all this was going on.
Our little cancellation babies, absolutely. It was amazing. God's compromise. My wife, Kristen, wanted 3. I wanted 5. We ended up with 4, and they're great. They're 2 now, and they're thriving. And part of this germinated on my Substack, Shapiro's Gavel, which talks about my personal stuff and other legal stuff, and basically things that I don't publish, on the op-ed pages of Wall Street Journal or City Journal or what have you. But then once it got into the other things, like researching these bureaucracies, thankfully I had research assistants and things like that, or the ABA. It was infuriating. It was annoying. I mean, I had to get through it because it's an important point to be made, I thought. I think it's an important book. I hope I wrote it up well. I slaved over the writing. I like Scalia, I enjoy having written. So I do have a good feeling about it now, but the labor itself was not always one of love.
It was kind of impressive, though. Tell me what you were telling me before we got on, that you would sit down at the computer every day for a period of time and write, whether it was 3,000 words or 300 words.
How I did it, my last book or this one, there's like a core 3-month period, because it's not sustainable, I think, longer than that, where, every morning, like 5 a.m. to 8 a.m., roughly, plus minus, I would sit down. Number one rule of writing a book is apply butt to chair, And I would try to limit distractions. I would just have my coffee, and whether that produced 3,000 words of gold or 300 words of crap, that's what it was. And after 3 months, about 90% was done.
You had a book. All right, Ilya. Well, the book is Lawless, The Miseducation of America's Elites. It's out now, and I encourage everyone to check it out. Thanks for coming on the show.
Thank you, Nico.
I'm Nico Perino, and this podcast is recorded and edited by a rotating roster of my FIRE colleagues, including Sam Lee, Aaron Reese, and Chris Maltby. This podcast is co-produced by Sam Lee. To learn more about So to Speak, you can subscribe to our YouTube channel or Substack page, both of which feature video versions of this conversation. You can follow us on X by searching for the handle Free Speech Talk. We're also on Facebook. Feedback can be sent to sotospeak@thefire.org. Again, sotospeak@thefire.org. And if you enjoyed this episode, please leave us a review on Apple Podcasts or Spotify. Reviews help us attract new listeners to the show. And until next time, thanks again for listening.